Okay, so hello and welcome everyone to Arbitration Academia's first online webinar on ODR and AI in arbitration as part of its launching event series. Just a disclaimer, anyone who's not speaking, anyone who's not talking, please turn off your mics and your cameras as you'll make this webinar easier for everyone today. So Arbitration Academia is the first platform offering online arbitration and ADR services in the Middle East. We provide a variety of arbitration courses to law students, to lawyers, judges, and arbitrators, mediators, everyone in between, and to all over the world. We also provide legal consultancy and dispute settlement services. For more information on what is Arbitration Academia, what type of services we provide, and where, and also if you're interested in attending our online webinars taking place this May, please do check the chat box. We have linked our website, our social media web pages, and soon we're going to share also a poster of our upcoming events. On May 8th of May, we have a webinar on construction arbitration in the Middle East. We're hosting Ashford Law Firm all the way from Wall Street and other speakers as well if you're interested. On the 12th of May, we have a webinar titled Women of Color in Arbitration in cooperation with Arbitral Women. We're hosting Amal Bushnaki from Herbert Smith Freeholds in New York, and Amanda Lee from Careers in Arbitration, and Shireen Fatih from Arab Arb, and much more. So without any further ado, in this webinar, we're going to discuss a timely and quite critical topic as well in litigation, arbitration, and even law tech sector. And it is online arbitration and the usages of artificial intelligence in arbitration. We're going more particularly to discuss issues of confidentiality, enforceability of arbitral awards as a result of ODR and blockchain. And thus by default, we're going to discuss the procedural differences between ODR and blockchain arbitration. And if we have the time, we're going to also entail issues of employability, access to AI robots, and much more. This webinar will run for 1 hour. In the first 30 to 40 minutes, we're going to have an enriching and hopefully fun discussion with our speakers. And in the last 20 to 10 minutes, we're going to open the floor for our speakers to direct any questions or any desired commentaries. For now, allow me to introduce our special speakers of this panel. Today, we have with us Ms. Elizabeth Chan, and also WeVaad. Ms. Elizabeth Chan is a registered foreign lawyer, England and Wales, based in Hong Kong. She has worked in arbitration and several elite law firms worldwide. As a matter of fact, she's worked in Allen & Overy, Hong Kong, Herbert Smith in New York, and also 3 Crowns in London. She specializes in international commercial and investment treaty arbitration, and she is ranked as a future leader of Who's Who Legal Arbitration 2022 to 2023, and the Legal 500 Arbitration Private Practice Power List in UK 2022. Ms. Elizabeth hosted the first ever virtual reality arbitration gathering in January 2022, which we're still all talking about until this very day. Welcome, Ms. Elizabeth. We're very glad to have you with us today. Second, we have WeVaad, and WeVaad is a private company and ODR provider based in India. On behalf of WeVaad today, we have Ms. Kritika Sethi and Ms. Yukta Joshi. Ms. Kritika is the co-founder of WeVaad, which is again a legal tech company providing online dispute resolution, legal marketplace services, and much more. She has previously worked in the disputes team of Amar Chan Bangladesh and has extensive experience in representing clients before different judicial and quasi-judicial authorities in India. Welcome, Ms. Kritika. We're very excited to have you with us. Finally, we have Ms. Yukta Joshi. She's a certified dispute resolution lawyer in India. She's associated with Singapore International Arbitration Center, London Court of International Arbitration, Chartered Institute of Arbitrators, Mumbai Center for International Arbitration, and finally, Young ICCA. She regularly conducts training sessions, produces voiceovers, and adds a mooted coaching and judges in with competitions as well. Welcome, Ms. Yukta, today with us. So The first set of questions, just to warm up today's webinar with our audience, are going to be procedural, let's say. So the first question, we're going to understand what is the difference between online arbitration and online hearing sessions, if there is any, right? Because there's a lot of scholars that tell you it's the same, right, Miss Elizabeth? And the second, we're going to define what is exactly blockchain arbitration. So starting with you, Miss Elizabeth, what is the difference between, again, ODR and online hearing sessions? And the second one, what is blockchain arbitration?
Great. Thank you so much, Noel and Arbitration Academia for the opportunity to be here, and hello, everybody. So I think the best way to conceptualize the differences between online arbitration hearings, online dispute resolution, settlement, and blockchain arbitration, but mainly the first two is really by reference to the different degrees of technological assistance that can be given to parties. Now, as you can imagine, there's a spectrum here. So, on the one hand, you have ad hoc arbitration, where the parties agree and establish the arbitration and the rules by themselves. They can decide to have the hearings online. And, sometimes the parties will choose institutional rules that will provide some certainty around the use of online hearings. And then, to the extent that you do decide to have an online arbitration hearing, well, then it's to the parties to decide whether they want to use the Zoom platform like we're using now, or Teams, or Skype, or whatever else they want to use. And that goes for any aspect of the arbitration. You could use Dropbox or Google Drive even if you wanted for saving documents. So there's a number of different ways where technology can assist with your arbitration. And then you have the middle of the spectrum where you're getting to institutional administered arbitrations, where the arbitral institution can administer can assist the parties in administering the arbitration both before and after the constitution of the tribunal. So now many institutions, particularly since the COVID pandemic, are now providing online and hybrid hearing services. But really, this was available well before the pandemic as well. For example, there were exit hearings online. We were using a form of cloud document storage with exit, and this was before the arbitration, before the pandemic. And then non-ODR capable institutions will need to agree and arrange for tools and support services to assist with the practical and logistical aspects of the arbitration system. So you can think of case management systems. So for example, I recently did a demo with Opus 2, where they allow the parties to access all of the documents relating to the arbitration. Everybody has the same copy, and then each of the parties can have their own copy as well that they can edit. Again, think of things like live transcripts, maybe a common procedural calendar, for example. E-bundling, that's a big one. I'm having something like I think it's Magnus, or like similar services where you have a provider that's going to show exhibits online. And then you sort of have, then at the end of the spectrum, you have ODR capable institution administered arbitration, where they provide an integrated law tech tools for you to use. So I think now I'll ask me later about the Hong Kong position, so I'll talk about that later. But essentially now you do also have institutions that provide a one-stop shop. So you go to them, to file all your documents online, you store your documents on their cloud system, you do the video conferencing through their system, they have cybersecurity protection, privacy protection, etc., and you do it all through this ODR platform. And just to answer Nawal's question about blockchain arbitration, actually, I want to correct what I said earlier. I would not necessarily put blockchain arbitration in the same category as ODR or online arbitration hearings. It's really an emerging form of dispute resolution and query whether it's even arbitration at all. So I don't think there's a generally agreed definition of blockchain arbitration, other than I think it should use some kind of blockchain technology to facilitate the dispute resolution system. As far as I'm aware, this is still very much emerging. So I have never used it myself, and I don't know anybody who's used it, but there are a number of different blockchain providers, among which is Kleros. I suppose there are a few things that define that are common across different blockchain arbitration platforms, although I would emphasize that there are many different ones. So one would be, storing information on the blockchain. Another would be, instead of having appointed arbitrators, like instead of having arbitrators, you might have jurors who are appointed not necessarily because of their legal expertise, but because they stake a number of tokens in this blockchain ecosystem. For example, you might not require a decision that has legal reasoning in the way that you would expect in a traditional award, but you might have jurors or people who have a number of tokens, and then they have to vote in a way that accords with the majority, and whatever the majority thinks is the outcome. And then you might have a solution or the result of the award, which is enforced on chain. So for example, whatever the decision is, then it automatically triggers a smart contract whereby, for example, some money is put in escrow, or cryptocurrency is put in escrow, and then it's transferred to the winning party. So some examples include like Kleros, Azure, and Aragon, and others, but I would definitely say that this is an emerging area, and we can talk a little bit more about the challenges associated with them later.
Absolutely.
Thanks, Noel.
Thank you, Lizzie. That was very elaborative, and you're definitely right. We think we should come back to discuss just the issue, especially when it comes to enforceability, right, of arbitral awards as a result of blockchain arbitration, which, as you said, we're still in dispute. Is it really arbitration or not? So we'll come back to that. Now, I will direct another question proceeding on confidentiality, right? So there's a lot of, arguments and discussion within the arbitration, litigation, and law tech sectors on, clients are concerned when it comes to confidentiality via or by using ODR or any form of virtual hearings when it comes to arbitration. So the question for Ms. Kritika, the co-founder of WeVaad, what are the video conferences medium that are used by WeVaad specifically, we would like to know, and ODR providers in general? For example, JAMS provide Zoom links and breakout rooms in Zoom for its virtual hearings. So how safe this can be, and are there any maybe technical measurements that ODR providers are currently using in some type of standardized way, to provide confidentiality and cybersecurity to its clients? And I always like to give an example for this. We have those Zoom links, for example, and I'm sure every and each one of us, when they attended one of those Zoom meetings, Zoom webinars, there was always some type of hacking or someone breaking in those rooms and those meetings. How safe are those rooms, and what is the difference between those links and that you provide as an ODR provider and those ones, for example, that the public can create and make?
Sure, that's a very, very interesting and a question that is posed to us by a lot of our clients. Firstly, I would like to thank Naval and our Academia for inviting us and for organizing this webinar on one of the most crucial topics, something that everybody currently is grappling with, to provide or to answer it for themselves, as well as to assure it to different parties who wish to avail it. In terms of confidentiality, one of the reasons why parties end up opting for arbitration as their preferred mode of dispute resolution is that they are able to maintain confidentiality with respect to the dispute, with respect to the facts that revolve around their dispute. And getting people to shift from an ad hoc arbitration, which is usually preferred in India, from an offline mode to getting them on an online mode, one of the basic needs that they usually are very concerned about is confidentiality. Now, in terms of the platform that WeVaad uses, WeVaad has its own end-to-end tech-enabled platform. So that not just for the purposes of conducting the hearings, but for the purposes of management of the matter and for the purposes of ensuring that all stages in that management of the matter are confidential and no party, apart from the parties to the arbitration and the arbitrator, has accessed, which is why we try and ensure in the platform itself that it cannot be breached. And in case, the access is limited and provided only to the parties to that case. Secondly, with respect to conducting online hearings and maintaining confidentiality with respect to those hearings, you had given a very good example to show, how Zoom has provided this feature wherein, you could go into separate breakout rooms, which is very essential, especially in a mediation or, in a conciliation, wherein the mediator or the conciliator would need to have those separate sessions with individual parties before they could have one comprehensive and consolidated session with all the parties. In terms of the platform that we use, we provide options to our clients, to the parties, as well as the arbitrators, to choose from the platform that are currently available, which ensure that confidentiality is not breached, which includes Zoom, WebEx, and your other options that are available. Because it's the comfort of the parties and confidentiality and privacy of the parties which has to be assured and which has to be maintained, which is why we ensure that we provide the options which ensure that, which in effect help parties in gaining more confidence in the whole online dispute resolution mechanism.
Thank you, Ms. Kritika. And so I think I would like to, just before I move out from this question, just because I think everyone is, here, including myself, this is kind of the most issue that we're fearing of is, again, what is there some type of standardized practice within ODR providers? Because now everyone are launching their online arbitration corporations, and for example, can web seals and those type of verifications modes actually provide more safety to clients?
Certainly. I mean, the moment you try and assess a particular software and how safe that software is for the parties, that builds the confidence, and using that certainly helps in terms of maintaining confidentiality, maintaining privacy of the matter, which is something that is assured even under our rules. So certainly, I completely agree with you there that those modes are relevant and are certainly something that we adopt currently.
Thank you, Ms. Kritika. So now going back, I think, to Ms. Elizabeth, right, regarding what we were just talking about, blockchain. So as promised, we're coming back to this. What type of enforceability issues that currently, practically, we are now as an arbitration, let's say, community facing regarding awards that are rendered via ODR and also blockchain arbitration? And what type of solutions or mechanisms that are viable and currently present for us to use?
Hi, now, while you asked about enforceability issues involving ODR on the one hand and blockchain on arbitration on the other hand, I do think we need to treat them separately, although I guess there might be some circumstances where issues would arise. I have to confess, I haven't looked specifically at enforceability issues that might arise in the ODR context. So let's assume we mean any international arbitration that uses some form of technological assistance, whether that's in the form of like document storage or a virtual hearing or something like that. Typically, I think during the pandemic, we might have seen some issues around whether participation in a virtual hearing is going to comply with standards of due process. And I think there we saw, a number of institutions modify their institutional rules to make clear whether virtual hearings were possible, and I think actually under the ICC rules that there might have been a note or some guidance indicating that the requirement for in-person hearing actually also included virtual ones. So I think there's been quite a lot of discussion already, and my understanding is generally that participation in a virtual hearing probably would not deny you due process so long as the parties had equal opportunity to present their case. But what I have also understood following the pandemic is that while it's become much more common to hold online arbitration hearing, the general consensus seems to be that online hearings are most appropriate, where you have like a procedural matter that's fairly simple, that doesn't necessarily require a cross-examination of witnesses and things like that. But unfairness can arise in the virtual hearing space, for example, because you're trying to juggle multiple time zones. And of course, you just had a conversation with Kritika about the confidentiality issues, and maybe Kritika, you might be better placed to explain whether there have been any challenges to awards where the hearing has taken place online. And then insofar as blockchain arbitration, that is something that I've looked into as I wrote a paper, I co-authored a paper on the enforcement challenges under the New York Convention of Awards that are resolved by blockchain arbitration with a colleague called Emily Hay. A lot of these issues actually remain hypothetical. We're aware of one decision where it's actually like where there was a case that was resolved via blockchain arbitration, I think the Claros protocol, and then the parties had agreed that another tribunal would essentially rubber stamp that decision. And then there was a question about its enforceability, but as I mentioned, there's actually very few or none, very few disputes that I'm aware of, which are resolved by blockchain arbitration. Although one caveat to that is I believe I've looked at the Claros statistics, and I think they say they've resolved, maybe around 1,000 cases or something like that. So I guess cases are being resolved, but I'm not sure we're necessarily seeing them being resolved in the courts. But just to very quickly answer your question about potential enforceability issues, one would be you might not actually have any enforceability issues at all. And via blockchain arbitration, the outcome of the arbitration is actually resolved on chain. So you bypass the New York Convention altogether. Another potential issue arises from whether you have a written agreement or not. Like if your contract is written in code, for example, would that satisfy the written agreement requirement under the New York Convention? Another example is potentially could the non-identification of parties and arbitrators become a due process issue under the New York Convention? So as many of so in the Claros, for example, jurors don't have to identify themselves, and they're chosen because of the amount of tokens that they're willing to stake. But right now we think it's really parties may say, actually, no, they really need to know who the arbitrators are. Maybe it's a due process issue that they don't know who that arbitrator is. Of course, we respect party autonomy and international arbitration. So there's a question as well about the extent to which the parties can agree to waive the due process rights, the boundaries of that is going to be. Another issue that can arise is what if the parties themselves remain anonymous, and that's an option permitted under the UK digital dispute resolution rules. A lot of people transact via wallets where they themselves are not identifiable. Yes, there are situations where the court, notwithstanding this, the courts have made certain orders which compel the disclosure of identity. But what if you have a blockchain arbitration where the parties actually quite happy to remain anonymous in the arbitration, but then when it comes to enforcing the award, typically when you go to a court, you actually have to say who you are and who the other party is. another issue could be, you know, whether there's a selection of a legal seat. I think increasingly as people are transacting virtually, it just kind of makes no sense to choose a legal seat. Like this idea that, you know, that awards, like you know, many pages of paper that it should have a nationality and that it should have any legal implications is actually kind of bizarre, right, to any lay person. So there's a question as to, you know, what happens if you don't choose a legal seat to govern your arbitration. You know, that probably would not satisfy the New York Convention, but, you know, that's something we need to reflect on as needing change. And then last but not least, public policy issues can arise. So as we all know, you know, the public policy exception to enforcing awards is generally very narrow and limited to international public policy. But the reality is with a lot of this new technology, new regulations, there's just a lot of like lack of clarity about what's allowed and what's not. And we've seen, you know, for example, in some jurisdictions in China where crypto is banned, then, you know, maybe you would have enforcement issues if your dispute had something to do with crypto. And we've already seen a couple of cases touching on public policy which involved like crypto elements, or, you know, exchanging awards from like a fiat currency to a cryptocurrency is raising public policy issues. So at this stage, like it was really interesting to write this paper and to theorize about a lot of this, but I think as yet we still have not seen, we still really haven't seen that many blockchain arbitral awards, let alone many attempts to like challenge them under the terms of the New York Convention.
Absolutely. That was very interesting, you know, and I think, you know, this is why there's a lot of debate. And I myself as well, you know, I'm obviously a traditional dispute resolution lawyer. And so, you know, in order for us to prepare for this webinar, I had to read a lot about blockchain arbitration. It's still something that we in arbitration trying to assess, to understand, to work with. And I think you put it brilliantly with the way that, you know, you lay down all of those grounds of how there might be an enforceability issues of blockchain, and thus due to that, can we really call it arbitration if you don't have a seat, if the opponent party does not know the, for example, who is the other arbitrator? There's a lot of due process issues and so forth, and putting all of this under the umbrellas of the New York Convention and even the neutral model laws principles. Again, can this be arbitration, or is it possibly a new developed dispute resolution mechanism? This is something to reflect on. Moving forward from this question, even though, you know, it was not intended to ask Ms. Kritika, but now we have to, because we're talking about, you know, enforceability issues of awards. And so very briefly, Ms. Kritika, can you be very brief on this regard? As an ODR provider yourself, and as a dispute resolution a lawyer working with online dispute resolution, what are instances, like real life examples of arbitral awards that were challenged or have some type of enforceability issues due to the usage of AI or online mechanisms?
Right. With the onset of COVID, what we saw in India is a complete shift from the perspective of judiciary, of shifting the hearings from offline to an online mode, right? So it was the judiciary, it was the government itself, forget the government, my apologies, but it was the judiciary itself which shifted from an offline mode to an online mode. And even as on date, there are a lot of tribunals that are currently functioning online, and in various cases, brief, but yes, still in several cases, courts itself are taking up certain matters online. So what it has taught us is that the shift that has happened from offline to online is leading to increased acceptance and acknowledgement of online modes and conducting it in a manner which increases the access to justice.
Thank you, Ms.
Just another question, Nawal, about, you know, challenging the enforceability of matters which are conducted online. Courts are conscious of the fact that it increases convenience of the parties and increases access to justice, which is why primarily because a matter is being conducted online, that has not been a ground in any of the cases to challenge the award that has been passed. And in any event, the grounds that are available to any party to challenge an award in India is already very, very limited. So they have to make out the threshold on them to make out a case to say that they were not able to represent themselves primarily because it was a virtual hearing is very high for them to contend something like this and for the courts to accept and set aside the arbitration. But we haven't seen any such case so far.
Thank you, Ms. Kritika. I think this is a topic that we can't really, summarize in 1 minute, but we tried our best. If we have any more time, I think our audience, if they want to, they can direct questions on this regard. Moving forward to Ms. Yukta. Ms. Yukta, can you tell us, again, very briefly about the developments of ODR in India specifically? And can we really, because, again, while I was looking this up, I've noticed that a lot of Indian lawyers and Indian arbitrators have linked COVID-19 pandemic to the development of ODR in India. So can you tell us a little bit about that?
Right. Thank you so much, Nawal, for this question. And also thank you so much for bringing all of us together here. With regards to the question on ODR developments, even the government has taken a lot of efforts in drafting a policy. So government has drafted the Niti Aayog has drafted a policy on ODR in 2021, and which stated a lot of measures on how we can implement and mainstream ODR mechanisms in India. So it also talked about a lot of challenges that exist presently and how we can cope up with them. So this is first is the government initiative. Secondly is that various government bodies have come up with different online portals to resolve particular kind of disputes, certain category of disputes. For example, if I tell you about the micro and medium enterprises disputes, so there's a specific portal called Samadhan in India, through which these MSMEs or these small businesses can lodge their complaints online, and they get resolved after that. So another initiative is by the for industrial disputes also. There's also Samadhan portal. One Samadhan portal is also created for resolving the industrial disputes. If you talk about the high courts, in India, various high courts have now started to come up with the regulations, mediation rules and regulations for empanelment of ODR institutions. So that is also a step ahead and a development after the COVID-19. And this way we are also recognizing ODR institutions. After COVID, many such institutions have come up and built themselves. Now, previously we did not have this concept of ODR institution, though we had these arbitration institutions and mediation institutions in offline mode, but recently we have observed the growth in this way also. If we talk about the investor intermediaries kinds of disputes, then in India, Securities Exchange Board of India have also come up with a portal called Scores. Through this portal, the people can register their complaints and they get resolved online. Then but presently the modes that are used are not like WeVaad as a specialized curated platform to have the online hearings. Now the SEBI uses the Zoom platforms and the WebEx and such kind of platforms, not in a very advanced capacity. So developments are happening, but it will take time, and the things that we're working we're working towards it. So yes, and in fact the Reserve Bank of India has also come up with the portal for resolution of the digital payments and the disputes around the financial sector. Yes.
Thank you. And actually, this is, I think, a kind of a timely example, because just quite a while ago, a couple of lawyers and arbitrators had a meeting with a banking, Arabs Banks Federation, and they were discussing also the potentiality of creating an online ODR dispute resolution mechanism. So quite interesting, and it looks like certain institutions are heading towards that. More on, ODR developments. I think we'll head back to Miss Elizabeth Chan once again to know a little bit more regarding that in Hong Kong, and maybe we can draw some parallels between Hong Kong and India on this regard. Miss Elizabeth, you're on mute.
Thank you. I just said I think we can draw parallels because ODR is growing both in India and in Hong Kong. So let me give you two examples. Like first, let's look at more traditional international arbitration, which is through the Hong Kong International Arbitration Center. So I wouldn't call that an ODR institution, but they are technologically very sophisticated. So for example, if you go to the HKIAC's virtual hearings website, you will see the range of services that they provide. So that includes equipment, so video conferencing capabilities. They have a virtual hearing suite. They have different platforms that they can offer. So for example, an IP-based video conferencing system supporting 8 different locations, cloud-based video conferencing, audio conferencing. They also provide support. So if you decide to hold a virtual hearing, you can write to the HKIAC about your requirements and they can work with you to find an appropriate solution for you. They have dedicated hearing managers, and they also partner with market-leading specialists for electronic bundles, electronic presentation of evidence, transcription and interpretation, etc. So basically the HKIAC offers a lot of technological solutions, especially if you want to have a hearing. And they also offer something called Case Connect, which I haven't myself used, but my understanding is that it's a cloud-based storage system where you can upload documents and there's a common procedural calendar. Now, moving to the end of the spectrum where you have a true ODR institution, the one in Hong Kong, which is government supported, is called EBRAM. And EBRAM is capable of being appointed to administer arbitrations, but it's also an ODR platform with an integrated set of tools that parties can use. So I refer back to what I talked about earlier with the spectrum. So EBRAM is, at the end of the spectrum where they're offering an integrated ecosystem of tools. So I actually did a demo, and what it looks like is, if you're a claimant, you log onto the website and you just they basically fill in a form. You say, who the party is, what your claim is, and then you attach your documents. This system is probably more used for lower value claims, which are fairly simple, accessible for the lay person. And then, you submit your documents and then there's a response. And then the platform already has video conferencing set up within it. So you're not using Zoom, for example, but you're using eBrand systems. And you can have, and all of it is designed to be online. So you're not having a discussion about, whether parts of it should be in person or not. And you can do mediation there. You can do arbitration. And I guess how it's really different to, a more traditional arbitral institution is that it's supposed to be a one-stop shop. Like you shouldn't need to go and get technological services from another platform, which may lead to cost savings, for example. And it's also good because both these institutions are eligible to apply to make law parties in arbitrations at these institutions are seated in Hong Kong have the right to go to the mainland courts to obtain interim relief, which is an advantage that exists for these institutions, which doesn't exist elsewhere. So so these are some of the recent developments in ODR in Hong Kong.
Thank you, Ms. Lizzie. And I think we were talking about Ibrahim a lot, you and I, before we had this webinar, and quite interesting. And I advise anyone to take a look at their website, quite advanced. And as you said, it's a one-shop stop. So, to continue and to proceed on this topic of developments of ODR and virtual means, there's another issue other than confidentiality that really arises when we're talking about ODR or blockchain arbitration, and it is the issue of due process, specifically when we're talking about inequivalent access to virtual means between opponent parties specifically. And so the question to Ms. Kritika, how does, and can ODR providers more specifically, right, deal with this issue of inequivalent access to virtual and technological means between opponent parties who specifically come from different countries, for example? How can we deal with this?
That's a very, very pertinent question, Naval. And this is a question, whenever we get people from different countries, we are very conscious of. When people hail from different countries, it's so important. Sorry, somebody spoke.
Yes, I just muted them.
Okay. So it's also important to understand the cultural differences between parties and, the value system that each culture has, which is why it becomes extremely important to have a mediator or have an arbitrator or conciliator for that matter, who understands the two cultures, and therefore the inequality is bridged to that effect, because you're able to understand what every person's perspective is, which is extremely important, say in a mediation or a conciliation, not so much in an arbitration. And which is where we take extra care to ensure that if our mediators are not well aware about the cultural differences, then they are trained to do so. And therefore, we are able to, help parties effectively in exploring mediation or conciliation as their preferred dispute resolution mechanism.
Thank you, Ms. Kritika. I think, to discuss another issue when it comes to ODR, and again, I think something that everyone wants to know about, and again, whether you're an arbitrator or a lawyer or even a mediator, and this question will be directed to Ms. Yukta, is, how does and can ODR providers deal with the issue of cultural communication barriers and differences via online platforms? So, there's a lot of, literature that has been published recently about that, arbitration or ADR disputes in general, and maybe even more mediation than arbitration, was designed to have a more party autonomy and access and direct communication between parties to come together and resolve their disputes, and putting those screens and those, let's say, barriers between them kind of create communication issues. And this is kind of more multiplied when you have opponent parties who already have communication gaps due to their different cultural. So is there any kind of developed policies or strategies to mend this gap that ODR providers has, for example, came up with, and more specifically WeVaad, for example?
Right. So for this, like when we meet online, there's often certain kinds of barriers, not only the physical barriers, but the cultural barriers, then the semantic barriers when the people can misinterpret the words or phrases used. There could be barriers as to the credibility of the parties and the accessibility. So as we know that for mediation or for conciliation, it's very important that there has to be good communication and rapport building between the parties. But we do face certain challenges when it comes to online communication, because parties are not in physical meeting. So, but we have certain measures that we adopt to bridge this gap. So, as one, like Ms. Kritika stated, that a mediator is someone who can ensure that such cultural differences can be taken care of while and effective communication can happen. The other options are, like, what we do is we maintain rules and regulations as institution, we have our rules wherein we maintain impartiality provisions and confidentiality provisions and the conflicts of interest, and all these provisions, we through these provisions we try to ensure that the parties feel very comfortable in an online setting and there are no such differences. And we also set the ground rules that when for example the when there are, say for example, the other party is not from our jurisdiction and some international jurisdiction, so they might not use such slang words or proverbs which might offend the other party. So certain ground rules can we can ensure to help the effective communication. And of course we make sure that the parties are well aware of the rules and regulations, and they understand that this is a formal setting and this has to be respected. So yes, these kind of, I think these proper communication coordination also plays a major role. So these measures in place can effectively bridge the communication and cultural differences gap.
Absolutely. Well, I think this is again something more for all of us who works in this sector to reflect on, and I think, this applies also to face-to-face arbitration. How can we really mend this gap, and how it really affects the dispute resolution process, and perhaps maybe, it is actually an essential maybe factor that leads to somehow some type of enforceability issue. Again, something to reflect on. Finally, we would like to end this webinar with a very interesting question. So we left the best to the last, as they say, and we're going to talk about AI bots. So with Miss Elizabeth, there has been a lot of discussion about AI bots, like specifically ChatGPT-4 and unequal access again, which, we're continuing to talk about the same issue. Again, unequal access by parties to that technology to assist them in their arbitration process. What issues, does this give rise to the arbitration and dispute resolution process, if any?
Now, while I think we're still trying to grapple with these very rapid and developments in AI and how that impacts the profession, but let me emphasize, first of all, that AI is not new. It's not something that just appeared with ChatGPT. We've actually been using AI for a very long time. Like when one of my old firms that I worked at, we were using an e-discovery tool where we were, I don't know if it was AI or machine learning or what it was, but it actually did a first cut of reviewing documents for us, or identifying duplicates or identifying documents that were similar. Similarly, there like forms of predictive analysis have existed in some time. I'm not so much aware of it being used in the arbitration space, but I understand that maybe in US litigation, it's a bit more common to use tools to analyze what a decision might be. So that's to say AI isn't new, but I think what is new is like the mainstreaming of AI, everybody being able to access, tools like ChatGPT, and really the legal profession waking up to the impact it's going to have on us. I don't have the answers, but I have a little bit of experience. So I was until recently employed at Allen Overy, which was, I believe, the first firm to use an open AI powered technology called Harvey, which is actually very similar to ChatGPT. And we were trialing that tool internally with our lawyers, and I sat in a focus group within our firm where we actually got feedback on how lawyers were able to use that tool. I think some of the feedback was people are still not sure how useful Harvey is for certain legal tasks, especially legal research, because Harvey was often not very accurate. And there's a technical term called hallucination, where they're like ChatGPT, and those forms of technologies sound very sure about the answer, but if you dig a little deeper, the quotes that it appears to quote actually aren't true, or the cases that it purports to cite are not true. I think I'm not like a techie person myself, but I suspect that some of the problems come from the source of their data. A lot of legal cases, a lot of legal decisions are actually behind paywalls. And unless whatever AI we're using has access to that information, how could it be give us the information that we need? and also ChatGPT, and I think similar bots don't necessarily have access to the internet, and so their information might be outdated. But in other ways, like these types of technologies can be incredibly useful. So for example, if you want like an outline of something or ideas for arguments that you can make, or if you want to like bounce ideas off ChatGPT, it's actually incredible. So like you can think of it as a sort of partner. So, and like, you know, I think individually it's really good to actually explore these different bots. So I actually use ChatGPT-4 on a daily basis. So let me give you an example that I was preparing for. It was a moot. And so I actually, you know, was able to put information into the ChatGPT to help me summarize the facts, help me summarize these documents. You know, tell me what you would include if you in a statement of claim, if you were the claimant's counsel, tell me what you would include if you were the defendant counsel. And I actually thought it was like very effective in referring to contracts or referring to general legal principles, which was all I needed to prepare for this. Also, there's actually, I think, a recorded version of the Vismoot where they had a human team against ChatGPT. So they had actors that would read out the responses by ChatGPT. And even though I think that the human team won, but I think the overall conclusion was that ChatGPT was actually incredibly powerful in doing that advocacy. I would say as well that AI is not just limited, like the use of AI in our personal lives is not limited to just using ChatGPT. I use AI in lots of ways. Like I use AI tools to take notes of meetings, take transcripts, and to summaries for me. I use AI bots to write LinkedIn posts for me. I use it to summarize news articles and things like that, organize meetings. So I think it's transforming and making more effective how we run probably also our personal lives, but also our professional lives. And then going forward, I can see, you know, plenty of issues around the use of AI in II. You know, you raised in particular the issue around equal access. You know, I query about that because if there are, you know, unequal access to arms, that already exists. You know, some people can afford, you know, very well-resourced firms, and some people have to be LA. So you already have that problem, but you know, I think we have to grapple with lots of questions about data privacy, for example, you know, whether clients actually even expect us to be using AI if we're not using it already, or like accuracy of this information. You know, what clauses are we going to put in place in engagement letters if lawyers want to use AI and need to get client consent? How do you protect a client confidentiality? So actually there've been reports of, you know, ChatGPT conversations that people, like some people are using ChatGPT like a therapist, and actually other users have been able to see the answers, which could be a problem if you put in client information. Other examples include, you know, Italy recently banned the use of ChatGPT and now has allowed it on a more limited basis. So, you know, global use and access to AI is not the same. So all this to say, there are lots and lots of interesting issues around AI, and I think it's good for us to have conversations like this.
Absolutely. You know, as you said, there's a lot of, for example, also Middle Eastern countries that, again, we're just talking about this before the webinar with another lawyer who's like, you know, I can't have even access to ChatGPT where I live. You know, if let's say my client who lives here can't access ChatGPT and it is used as a mechanism of dispute resolution, what can we do, right? So, you know, very, very, as you said, and data privacy, very, very interesting, you know, topics and layers. And I think it's just another field for us lawyers and practitioners in arbitration to learn, because, you know, we're going to be main practitioners in this, and maybe even leaders. And so, and we're just learning, you know, we're just trying to see how practice will lead us. As you said, for example, blockchain arbitration, we still have only like maybe 2 cases that are very well known that we can, you know, write about, we can unlayer, we can study, but other than that, it's still very new. do. You know, so much more to it, so much more to it. So with this, I would like to end our webinar. I hope everyone had enjoyed all the issues and all the topics we have dealt with, confidentiality and ODR, blockchain and ODR, online hearings, and what is the difference between online hearings and ODR. And also we've finally talked about the issues of due process and specifically in equal access. And we finished with AI robots. Before I'm going to let everyone go, if anyone has any question, any comment to our speakers, please go ahead and send it to us in the chat box, or just send me a text so I can unmute you if you wish to speak directly. Yes, absolutely, Elizabeth. We definitely should take a screenshot. Let's do it.
Right, shall I go ahead?
Yes.
For those who want to be part of the screenshot, which we can put on social media, please feel free to turn your cameras on. Okay, so now, all right, okay. Oops, sorry. 1, 2, 3. Perfect. Let me, okay, sorry, if someone closed their eyes, so let's try that again.
Okay.
Okay, 1, 2, 3. Perfect. Thank you very much.
Perfect. Perfect. So let me check the chat box once again. Okay. It doesn't look like we have any question or comments. So one last call just before I turn the call off. Okay, I think we're good to go. Thank you, Miss Elizabeth. Thank you, Yukta and Kritika from WeVaad. We are sure we're going to host plenty of other workshops and even training sessions together in the future. So everyone stay tuned. And as I said, if you wish to attend our other online webinars, please do check our social media pages, Arbitration Academia, or our website, www.arbacademia.com. Good morning or good night, wherever you are. Goodbye.
Goodbye.
Thank
It was
you
such
so much.
a
Goodbye.
part of this panel. Bye-bye.